Good afternoon and welcome to Broadband Breakfast Live Online. Today is Wednesday, February 21st, 2024. My name is Drew Clark. I'm the editor and publisher of Broadband Breakfast. We are very excited to have five real experts on this topic of social media in the courts. There's two blockbuster cases coming up before the Supreme Court. And we've got four out of our five panelists have a dog in the fight. One of them does not, but certainly follows this. And we're going to kind of dig into really all aspects of this controversy, maybe some of the antecedents to it, and some of the possible impacts of it. But before we get to that, and before I introduce our panelists, I want to again welcome all of you to Broadband Breakfast Live Online. If you haven't been here before, welcome. We do this every week on Wednesday at 12 noon Eastern time. We've been doing it nearly 4 years since the pandemic first had its big impact. And it's our way to kind of connect the community around better broadband, better lives. We focus on high-speed infrastructure and the impacts that it has, as well as the controversies around privacy, net neutrality, social media section 230, and the like. For those, again, of you who maybe are new to Broadband Breakfast, we've recently revamped the website. The page for this event now has commenting capabilities. So all you need to do is get a free account at Broadband Breakfast, and you can ask questions that will live forever there. You obviously can ask questions here in Zoom or on the other platforms that we're streaming. And I pay attention as well as I can to the other platforms. Zoom questions in the Q&A box get probably the first priority because they're easy to see. And I do encourage you to put them in the Q&A, not in the chat stream, although we have enabled that, I guess, for free speech purposes, for you all to communicate among yourself who you'd like to. We've got some great upcoming events on Broadband Breakfast Live Online. And just to kind of slightly new URL. The old one will still take you to where you need to go. But this URL that I'm popping into the Zoom chat box, and I will put it in others later, will show you all of the upcoming broadband live events. Obviously today, social media in the courts. Next Wednesday, February 24th, we're going to be talking about broadband mapping and broadband labels. In the week of the 6th, we're going to be talking about state digital equity plans, and the week of the 13th, quantum computing and broadband. And I particularly want to call everyone's attention to our upcoming Broadband Measurement Summit. That's an in-person event that will take place at Clydes of Gallery Place on Thursday, March 7th, just a little over 2 weeks from now. The early bird rate is going to be available till Friday for $195 for the all-day event focusing on measuring broadband speeds, prices, availability, reliability, and competition. Feel free to email me, drew@breakfast.media, if you've got any questions about that event or any of our other upcoming events. And then lastly, before we turn to our panelists, I want to thank the sponsors of Broadband Breakfast. Sponsorships allow us to do this programming every week for 4 years now. They include Utopia Fiber, Broadband.money, Comcast, SmartWave Technologies, Ookla, Wesco, Coos Systems, the Community Broadband Networks Initiative of the Institute for Local Self-Reliance, the California Emerging Technology Fund, Broadband Toolkit, Google Fiber, Broadband Now, and Michael Baker International. Thank you to our sponsors. With that, let's go ahead and open up our gallery view. We've got, as I stated a little bit earlier, 5 experts on these topics of social media in the courts. And I'm going to introduce them in the order that they will speak by giving opening statements, if you will. And then we'll kind of dive in with a moderated conversation among the 6 of us, and of course, each of you as you put your Q&A in the different platforms. We will hear first from Andrew Nichols, who's a partner at Charis Lex. And Andrew focuses on appellate proceedings and high-stakes motions at the trial level. He handled diverse commercial and constitutional litigation, helping build an appellate and critical motions practice. And most particularly in regard to these matters, Andrew has been involved in not just the case that we're talking about here, the two net choice cases, but he's also involved in Murphy versus Missouri to be argued by the Supreme Court next month. So all good things to be aware of for our leadoff speaker there, Andrew Nichols. Andrew will be followed by Carl Szabo. I hope I pronounced that close, Carl. Carl, we appreciate you having been at our previous event, the Big Tech and Speech Summit we held almost a year ago. And I guess we previewed many of these arguments. Of course, the Supreme Court, I don't think, had decided to take the two net choice cases, the Florida and Texas cases. One, of course, ruled the Fifth Circuit, I believe. Well, you'll correct me. I guess it was Texas got the ruling in the Fifth Circuit was for Texas, so you're the appellants in the net choice versus Paxton, whereas the Florida case, Moody versus net choice, the 11th Circuit did not uphold the state's laws. But Carl will tell us a lot more about that. He's net choice's vice president and general counsel, and he analyzes, advocates, and testifies on tech-related legislative and regulatory initiatives relevant to online companies. So thank you so much for being with us, Carl. Following Carl, we're going to hear from Ash Bhagwat, who is a distinguished professor of law and the Buchever and Byrd Endowed Chair at the University of California, Davis School of Law. He is one of the leading First Amendment scholars in the country, and he's the one who doesn't have a dog in this fight. So I'm going to listen very carefully to what Ash has to say when he speaks. Our last two speakers are Thomas Berry. Actually, last three speakers, excuse me. Thomas Berry, or Tommy. He's a research fellow in Cato Institute's Robert A. Levy Center for Constitutional Studies, and he's the editor-in-chief of the Cato Supreme Court Review, which is fabulous publication. And I go as many years as I can to Constitution Day at the Cato Institute to hear the very topical analyses of the recent term, as well as a look ahead to the next term. So Tommy's going to update us on this. Cato does have a brief, I believe, or an amicus. He'll clarify for us, but Cato obviously is a very significant think tank and player on free speech issues. So thanks for being with us, Tommy. And then our last speaker will be Scott Wilkins. Scott, you're the senior counsel at the Knight First Amendment Institute, and he brings nearly 20 years of litigation experience in private practice, focusing on freedom of speech online and government regulation of social media platforms. And you said that you filed an amicus brief on the Institute's behalf in Google versus Gonzalez, which was kind of maybe like a half charged case that didn't really fully squarely deal with these issues, but many of us thought they would deal with those issues. So certainly want to hear how that predecessor matter, Google v. Gonzalez, and I think it was Tamara, I forget the name, for Twitter case. Both of those came together and came with messy facts, but certainly laid the groundwork for these two landmark cases that the Supreme Court's arguing in 5 days. Well, that's enough for me. Let's turn to our first speaker. The floor is yours, Andrew.
Thank you, Drew. Appreciate it. I'm grateful for the chance to do this and to talk to your audience. The question the court is going to consider next week, I'm going to oversimplify it just to be able to be brief. But what can states do in the way of requiring large websites to carry certain content? And the states have framed this in terms of neutrality. What websites must keep up, not mostly not what they must take down, but what they must keep up in terms of neutrality. So what I wanted to say with my little introduction to frame our conversation, hopefully, is what do we think the court will do in these cases next week, and then what should it do? So I'm going to start a little more neutrally and then go into what I, in the brief that I filed on behalf of the International Center for Law and Economics, we think the court should do. So what will the court do in these two cases, these NetChoice cases? NetChoice is the umbrella organization that Carl represents or works for, and that is in the crosshairs of these state laws. They're laws by Florida and Texas. What will the court do? Well, I think here, as so often is the case, a page of history is worth a volume of logic. What has the court done in the past? That's what I would encourage us to look at. Last year in Google v. Gonzalez, in which I filed a brief for 12 think tanks, the issue there was, what is YouTube's liability for its algorithms? Well, the court skirted the hard issue. Justice Kagan famously at the argument said, quote, "We're not like the 9 greatest experts on the internet," end quote. And that got a huge laugh, and it got a huge laugh because everyone knew she was right. But it wasn't just Justice Kagan, and it wasn't just the court in that decision. It's a theme the court has been drumming. In 2017, the court unanimously said that it wanted to show extreme caution in internet cases. And because the internet is new, is protean, it's changing, and it said what courts must be conscious that what they say today might be obsolete tomorrow. And so the court there struck down a North Carolina statute that made it a felony for sex offenders to access a lot of websites like Facebook and Twitter. So I think the interesting question here in these cases this next week is, what is the extremely cautious thing to do with the Florida and Texas laws? That's where the court is going to want to migrate, because I think they're freaked out about the internet. Still, as long as it's been around, it's old to us, but it's still relatively new to the Supreme Court. So will they say, let's strike it down, leave the internet untrammeled by Florida and Texas? Or is that an aggressive thing to do? In fact, is that activist and anti-democratic? So I think that's the question that the justices at the bottom of everything are going to be wrestling with. As for what the court should do, again, now I'm going to put on my hat of the clients I represent. In this case, a page of history is worth a volume of logic. No one has ruled big tech for long. IBM was dethroned by Microsoft. Hewlett-Packard was beaten by Apple. AOL was bested by Yahoo. Yahoo was knocked off by Google. I mean, the Fifth Circuit, in the decision the court's taking up next week, called Twitter a monopolist. Well, the ink wasn't dry on that decision before Twitter got bought by a free speech, self-proclaimed free speech absolutist. So my client's position, the position I've taken for think tanks in all of these cases, is that the court should let the free market sort this out. It's doing a very good job, a better job than we often give it credit for. We just look at, for example, NPR did an article a couple of years ago saying Ben Shapiro rules Facebook. So what should the court do? Our position is it should be extremely cautious, like it said it should do in 2017, and strike down these laws.
Thank you. Let's turn it over to you, Carl. Tell us a little bit about how NetChoice got the honor or burden of carrying these two cases.
Yeah, thanks, Drew. Thanks for having me here to speak. I really appreciate it. And yeah, as you identify, we certainly do have a dog. We have a big dog in this fight, since we are the named plaintiff in both these cases. So let's roll back the clock to 2001. 2001, you see a bunch of state lawmakers on the right get very upset about content moderation decisions made by Facebook or Twitter at the time, and a couple others. And they have this knee-jerk reaction. And they said, you know what, that's not fair. We are being cut off from access to be online. Well, you know what, anytime somebody tells me that they're not going to publish my op-ed, I get upset about it. So yeah, I kind of get it. As a conservative, as a Republican, I get upset about content moderation decisions that are made. But then these states took this remarkable leap, this absurd leap, to say, you know what, social media platforms, we are going to deny you your right to operate as a private business. We are going to deny you the right to decide what is best for your users and your customers. We are going to tell you what content you must carry. We are going to compel you to carry speech that you don't want to carry. And this idea kind of took hold in Tallahassee, it took hold in Austin. And so NetChoice traveled repeatedly down to both those cities, both those capitals, to meet with those lawmakers, to talk to them, to outline how this is bad from a policy perspective, because you don't want states like maybe California or New York saying to platforms and websites that they must host or remove speech. We explained how this is bad from a principles perspective. It's kind of against conservative principles for the government to come in and start forcing businesses to do something that they don't want to do. And then we explained it from a legal perspective. So we hired an outside law firm, DLA Piper, and paid for a voluminous brief on the First Amendment violations of these laws. And we didn't hide the ball at all. In fact, these were attached to our testimony, both in person, oral, and meetings. And we're like, no, this is a bad idea. And unfortunately, they didn't listen to us. And so that kind of put us in a position. Well, these are now the law. What are we going to do? And NetChoice took up the banner, seeing litigation as the last resort, and we brought suit alongside our co-plaintiff CCIA against the states of Florida and Texas over one simple idea. The First Amendment forbids the government from forcing somebody to say something they don't want to say. And fortunately for us, and Andrew kind of alluded to this, we have 200 years of First Amendment decisions on our side. We have cases just as recently as last term, like 303 Creative, which we'll get into probably throughout the course of this discussion. But there's one case in particular that I think is worth discussing, and then we'll kind of move forward, which is a case called Miami Herald v. Tornillo. And as you can imagine from the name, Miami Herald involves a newspaper, in fact, the Miami Herald newspaper. And this is a case that took place in the state of Florida. So this is a case on point. It's one of those things lawyers love to have that we never usually get. And in this case, the state of Florida told the Miami Herald, you must carry an op-ed from politicians, even if you don't agree with it. Well, the Miami Herald said, no, this is our editorial page, this is our opinion page. We get to decide who gets onto the op-ed page. And they rejected that politician's op-ed. Well, the politician said, well, under Florida law, Miami Herald, you must carry it. And this went all the way up to the U.S. Supreme Court. No, near unanimous decision, the U.S. Supreme Court said, Florida, no. It is a violation of the First Amendment to force a newspaper to do something against their editorial discretion, to force them to carry content that they do not want to carry. And it's really illustrative for the case that we're talking about today and that will be before the court this upcoming Monday, because it's the same thing. They're saying to websites, essentially online publishers, that no, you can't remove content that you don't want to see, that your users don't want to see, that you don't believe in, that doesn't match what you're trying to do on your website. No websites, you can't arrange content in the way that you want. And so that's what's really before the court. It is, does the First Amendment protect and apply to websites? And based on the 200 years of First Amendment law, we expect the court to rule in our favor, coupled with the policy threats of giving government more control over censorship and what content can be seen, heard, and read online. So we are now before the U.S. Supreme Court. Didn't expect to be here. Was kind of hoping that we didn't have to be here, but we are. We're going to win on Monday. And thank you for having us on this panel.
No, it's great to have you. Thank you for your concise summary. Let's turn now to our next panelist. We're going to hear from Ash Bhagwat.
Thank you, Drew. I apologize in advance for background noise. For some reason, construction just started in front of my house. I want to talk a little bit about the big picture in the NetChoice cases. So what the fight is one of analogies, because we're lawyers and we like to analogize. On the one hand, Florida and Texas want to analogize social media platforms to common carriers, like telephone companies who basically have an obligation to carry everyone's content. Telegraphs before that. On the other hand, as I think we just saw, NetChoice would like to analogize platforms to newspapers. And if that's true, if they're just like newspapers, then I agree the Tornillo case controls. One funny thing in the Tornillo case and in the current Florida legislation, the Florida legislature chose to give special rights to politicians, which I think I want to take a pause on how absurd that is in the free speech arena. I have little doubt that as a legal matter, the right position is that platforms have editorial rights. I mean, I recently published an article saying, do platforms have editorial rights? That was the title, and the short answer is yes. Not because platforms are exactly like newspapers, because of course they are not, but because first, there is a long tradition of editorial rights for media entities going back to printing presses in the 18th century, where we think that people who own media are entitled to decide what to disseminate. And I'd add, in many ways, printing presses in the 18th century are a better model for modern social media than modern newspapers, because printers printed all sorts of stuff. They didn't just print their own stuff. In fact, primarily, if you look at what Ben Franklin was printing, it was not his own stuff. It was basically printing third-party content, much like current platforms. Honestly, I don't actually think that's a terribly close case. I suspect that this Florida and Texas governors knew that they were probably going to lose this case. And so it's not, I can't predict what the Supreme Court is going to do. Clarence Thomas has already planted his flag in the common carrier category, but the other justices, I suspect, are not going to go along. What I want to say about this is, while we have to do analogies, because that's the way lawyers work, it's important to recognize that there is no perfect analogy. Modern social media platforms are a completely new technology. They are not newspapers. They are not telephone companies. They are not printing presses. They are something different. And the main reason they are different is the combination of third-party content and sheer volume. I mean, the amount of volume that Facebook carries every single day is inconceivable in anything that existed 30 years ago. We need to come up with new models of governance. We need to recognize that these analogies are not perfect, and that there are issues that need to be addressed in the social media sphere, especially involving minors. And we need to come up with some way to reconcile the idea that we need some governance in this space with a continuing recognition that the First Amendment is fundamentally founded on not trusting the government. And we should not trust the government with this media any more than we've trusted the government with previous media, because what we'll see is politicians, when they regulate, will regulate in ways that are to their own benefit. And we don't want politicians. If you look at the statements by the Florida and Texas governors, they basically say the purpose of this law is to enhance conservative voices. And if you look at liberal proposals to regulate the internet, it's always about suppressing voices that the liberals don't like. So we shouldn't trust any government officials to regulate in this space. And any models that the courts come up with need to reflect, A, the idea that we're dealing with a whole new set of issues, and B, but there's an old tradition of not trusting the government that we need to stick to. The other thing to keep in mind, though, and reason why I think the court should be extremely cautious in this case is, we don't know where social media are going to end up. This is still such a rapidly changing technology. In many ways, the problems that Florida and Texas are addressing in their 2021 laws are problems of the past. Twitter, as has been pointed out, looks completely different under Elon Musk's ownership, than it did 4 years ago. And where it's going, whether it's going to be around in 2 years, and if it's so, where it's going, nobody knows. Facebook has notably moved heavily away from political content. Mark Zuckerberg has made a conscious decision to try and emphasize, first of all, non-user generated content, and second of all, non-political content on his stream. So the problems that we were talking about really have become very secondary on the Facebook platforms. And where the other platforms are going, what TikTok is going to look like, we just don't know. And so I think that it is right that the court should take a very, very cautious approach, because until things settle out, adopting governance models that are out of date in a year or two is silly. Last point on this is the dog that didn't bark. One of the odd things about these cases and the way they've been litigated is they've been entirely focused on First Amendment issues. I'm actually curious if Carl has something to say about why, because NetChoice has made those choices as well. But of course, lurking in the background is Section 230 of the Communications Decency Act, in which Congress has regulated social media content moderation practices. And one of the arguments that really has not been much raised, I mean, it's out there, but it has not been much discussed, is, does Section 230 simply preempt state law in this area? I think there's a pretty strong argument to be made that it does. And if the Supreme Court wants to go a cautious path, that would be a way to go, because that doesn't resolve any of the difficult constitutional issues. I don't think it's difficult, but that doesn't sort of force the court to take a strong stance on constitutional issues. It continues to give Congress the capacity to do what it wants, since 230 is after all just legislation. And it would make the problem at least temporarily go away, but leave open the possibility of future experimentation. And so I wonder if that's not what they're going to do.
Well, thank you for raising that. Raises a lot of good questions for us to get at. Let's get Tommy and Scott into this conversation. The floor is yours, Tommy.
All right. Well, thank you so much for having me. I wanted to focus a bit on why I think that the conservatives supporting these laws are making arguments that are short-sighted and that they're not fully grappling with the consequences of how the law would change if the court accepted the arguments they're making. Opponents of the law, I think quite rightly, are focusing on Miami Herald versus Tornillo as their best case. They're making the analogical argument that was discussed that we should think of these platforms as somewhat like newspapers. The counter argument and the case that was most relied on by Fifth Circuit Judge Andy Oldham in the opinion he wrote upholding the Texas law is a case called Pruneyard Shopping Center versus Robbins. And this analogizes social media companies not really to publishers or even speech disseminators at all, but essentially just to real estate. So Pruneyard was a case where the California Supreme Court interpreted California's constitution to give a right to access even privately held real estate, private shopping malls. You now had a right to picket, pamphleteer, hold protests on private open-air shopping malls as if they were public parks. So the private shopping mall appealed this to the U.S. Supreme Court and said this violates our First Amendment right to decide what speech does and does not appear on our real estate. And the Supreme Court, in an opinion by then Justice Rehnquist, before he became Chief Justice, said, no, this is okay. This complies with the First Amendment. And the main rationale he used was you can just put up a sign that says, we're forced to host these picketers. We're not endorsing it. And so that would reduce eliminate any harm of false appearance of endorsement. So Texas is basically arguing, and a lot of conservative supporters are arguing, that social media sites can do the same thing. They can put up a disclaimer at the top of their website saying, anything you see on here that may seem appalling, pro-Nazi speech, what have you, hate speech, we're just forced to post that because of this law. So you can't assume that we're endorsing it or that we had any choice in the matter. Now, what's the problem if Pruneyard? First of all, Pruneyard has never been extended to businesses in the business of disseminating speech, essentially publishers. It's only been in the real estate model. I mean, these were malls that essentially didn't want to be in the speech business at all. They just wanted to make it easier for people to shop without having political things around them. That was the only reason. In fact, even in the briefing in Pruneyard, they didn't explicitly want to say that they opposed the speech that they were being forced to host, which maybe was a strategic mistake, but it was noted in that opinion and in later opinions that they had not made that argument. Now, if Pruneyard is extended for the first time to people in the business of speech dissemination, what other consequences might happen? Well, imagine a small bookstore, a small privately owned, say, conservative or Christian themed bookstore, and imagine a state publishes a non-discrimination law for private bookstores and says you can't make any choices based on the viewpoint of the books in what you choose to sell and not sell, or even what you choose to put in the front window versus what you choose to put way in the back. So imagine a Christian bookstore said, we have a certain point of view, we have a right of conscience, we don't want to host, sell communist books or pro same-sex marriage books or what have you. If the Supreme Court extended Pruneyard, they would probably be out of luck. They wouldn't be able to rely on 303 Creative, the decision last year, because that was specifically about speech creation. This is really about speech dissemination, the right for what speech to control what speech you host, amplify, whatever verb you want to use. And so I think a lot of conservatives might be short-sighted or not realizing that this would be a tool wielded by liberal states just as much. In fact, we saw a lot of this was recognized by then Judge Brett Kavanaugh in a dissenting opinion when he was on the DC Circuit in the case challenging net neutrality. He argued, and I think correctly, that those regulations violated the First Amendment under Supreme Court precedent, and he raised a bunch of hypotheticals and said, look, if you accepted this, could you force a private bookstore to host books? Could you force Amazon to sell every book without discrimination, and so on? So in the long run, I think Pruneyard was wrongly decided, and the Supreme Court should overturn it. They don't have to overturn it for NetChoice to win these cases. But I think what I hope is that they will at least note what an outlier it is and how inconsistent it is with a lot of other Supreme Court precedents. Argument at greater length in Cato's amicus brief, that it's inconsistent with, for example, the right not to have live free or die on your license plate. It's inconsistent with the right not to fund union speech that you disagree with. In other cases, the court has recognized a right not to amplify or platform speech, and I think that right applies just as much here.
Wonderful. Thanks. Thank you, each of you, for bringing in new perspectives and issues in the conversation. So batting cleanup, we're going to hear from Scott Wilkins. Tell us a little bit about your take on this before we go to a general conversation among all of us here.
Sure, and it's great to join you and the panel on these really important cases. I'll first note that my organization, the Knight Institute, filed amicus briefs not just in the Gonzalez case, which is about Section 230, but also in the cases that will be argued next week, the NetChoice cases, and also in the Murthy case that's coming up later. I think we share very much the position that's been expressed by pretty much everybody so far with respect to the must-carry provisions of the Florida and Texas laws, and that in essence, there is a right to editorial judgment that social media platforms have, and that telling them what they must keep up, what they must publish, is a violation of that right. And that I think is very clear, and I think pretty much all of us agree on that. But I just want to add a couple of important considerations here. I think in terms of framing, it's important to see that both sides in these cases take extreme positions. The states, to be sure, basically argue that the platforms have no First Amendment rights with regard to content moderation, and that the states could then therefore basically regulate as they wish in that space. So that's certainly an extreme First Amendment argument that there are no such rights. And then the platforms, for their side, take also an extreme view of the First Amendment rights of platforms, and in essence argue that any infringement of content moderation, any regulation of content moderation is subject to the highest level of judicial scrutiny and almost certainly is unconstitutional. And we think, and we've argued in our amicus brief, that both of those positions are wrong, and that even though the Texas and Florida laws must carry provisions are clearly unconstitutional, that does not mean that the First Amendment prohibits all regulations of content moderation, and that in certain situations, for example, carefully drawn transparency requirements, a much lower level of First Amendment scrutiny should apply. And we generally refer to that as Zouderer, which is the Supreme Court case at issue. And that has been applied in the past to commercial disclosures, and we think that that should apply here. And so I think that's an important sort of qualification to the First Amendment right to editorial judgment that we should bear in mind. Now, these cases, both the laws here both included extensive transparency requirements. Those provisions, with only one exception in each law, those provisions are not before the Supreme Court in the case in these cases that are being heard on Monday. The Supreme Court limited the scope of its review, and only one type of transparency requirement is really at issue. So we'll see how much they have to say about the legal standards that govern transparency. Let me also just respond to one important point that Ash raised, which is about Section 230 and how that kind of fits in here. And the platforms, NetChoice, has made Section 230 claims in both lawsuits, and in the Florida case, they actually moved for a preliminary injunction on that theory as well as a First Amendment theory. But I don't think the Supreme Court can really rely on Section 230 to find a way out here, because that has not been raised at all before the court by the parties. It's not part of the questions presented, and so I think it would be hard for the court to use that as a way out here. So I think they are going to have to address the First Amendment question straight on, and I would agree with all of those who've said that they're likely to be very cautious here. They're likely to try to issue a narrow ruling, but we'll have to just wait and see what happens.
All right. I want to ask the question I did post on the page. And again, reminder that to those who want your question to live on, feel free to log in for free as a Breakfast Club member, Broadband Breakfast member. My question is, are the tech and media industries, what we sometimes think as the mainstream media, united or divided on the First Amendment issues raised in these laws? And obviously, Carl referred to Miami Herald, which, First Amendment, absolutism, and highlights the difference between the standard of speech for electronic media. Tornillo was decided 2 or 3 years after Red Lion, in my opinion, one of the worst First Amendment decisions by the Supreme Court that hasn't been overruled. And the question I'm asking is, we sometimes hear about this distinction between platforms and publishers. And I would just really love everyone's perspective on, are these interests going to be aligned in this case and in others going forward, or will they begin to diverge?
Happy to take a first cut at that. I think traditional media, especially newspapers, but not exclusively newspapers, in the long term, their interests are not aligned with platforms. And the reality is that the reason is that, as we know, the spread of social media has been a disaster for the existing journalism industry. It's in terms of revenues lost and readership lost. And so in the long term, and we're seeing this starting to happen in some other countries, is they have an interest in access rights to platforms as a way of spreading their word. And that's in tension with the idea that platforms have First Amendment rights. I don't think any of the traditional media have taken a strong position, but I think in the long term, there's going to be a clash. I don't see how there couldn't be.
So I'll kind of add on to that. So Drew, it's a good question. So I'll look at simply who has filed amicus briefs in support of NetChoice and CCIA. And you have the Authors Guild, you have the Motion Pictures Association, you have a lot of newspapers that are filing in support of NetChoice and CCIA. Similarly, we have cases out in the state of California, for example, where you saw a bunch of newspapers file in support of NetChoice. We're the solo plaintiff out there on a similar but different First Amendment issue. You got the New York Times, the Boston Herald, the Washington Post. A bunch of newspapers are filing in support of NetChoice, and because it centers on the First Amendment. And at the end of the day, what we are seeing is that newspapers, publishers across the gamut, whether you like tech or not, recognize that this is all about protecting free speech, whether it is an online newspaper, whether it is an online website, whether it's a social media platform. It's all about the First Amendment. The other thing, and this gets to your other question, which is this distinction between a publisher and a platform. You can be both. It's kind of like a sweet tart, right? It can be both sweet and tart simultaneously. Websites are similar. They are both platforms and publishers. They are platforms when it comes to other people's speech. They are publishers when it comes to what speech they want to allow on their platform. And they are and they are publishers when they get to decide what content they want to be associated with. If I'm creating a platform that's only about talking or discussions about the Supreme Court, and we saw this in one of the amicus briefs filed by the moderators, the user moderators of r/SCOTUS, a Reddit subreddit, they only want to talk about the Supreme Court issues. And they go and engage in content moderation decisions. So if you want to talk about politics, you can't. If you want to talk about dogs, you can't. And that is their editorial discretion. And that is where they are publishers, because they are engaging in editorial discretion as to what type of content they want their subreddit to be associated with. So we're feeling pretty good. We're feeling like this is a false choice in the, are you a publisher or are you a platform? Because they're both. And thus the First Amendment still applies.
It seems like we might helpfully, so everyone has the bigger picture, also acknowledge that the separate set of cases that are working their way through the courts, and one of which the Supreme Court's going to hear next month, does create a bifurcation among conservatives and within the tech sector on these issues. And what I mean is this: that case involves private, what's called jawboning by federal officials. And the plaintiffs in the case are very high-end doctors and professors at elite institutions, as well as a couple states who said, yeah, your jawboning, federal government, got us taken down off of Twitter. Thank you very much. And that effectively violates our First Amendment rights. So there are user rights that are at stake. But when they sued the federal government, that left the platforms on the sidelines. And the platforms weighed in, and they weighed in support of neither party. And you can see why it's an uncomfortable position. Maybe Carl doesn't want to say anything about it for that reason. It's an uncomfortable position because they were trying to, you can see in the record, do what the government wanted, but at times they pushing back and saying, we don't want to do this. And so I think that's another place where you see fault lines developing, because they're trying to play along, and that's part of the problem. And it's actually part of the theory of the plaintiffs in the case, that there was coercion that violated their First Amendment rights.
Yeah, just real quickly, because so NetChoice actually filed an amicus brief correctly in support of neither party. This is a case called Murty. It's before the U.S. Supreme Court later this month, or early next month. And the question before the court is, can the Biden administration pressure social media platforms to remove content that the social media platforms don't want to remove, and promote content that the social media platforms don't want to promote? And this is centered around the First Amendment rights of social media platforms in particular. So is there a First Amendment right for social media platforms to not be pressured by the federal government? In this case, it's the Biden administration, as opposed to our cases, which are the states of Florida and Texas. And it puts people on the other side of the dais from us in a really tough spot. Because if Florida and Texas win their cases and the First Amendment does not apply to social media platforms, does not apply to the internet as they seek, that means that the cases on Biden pressuring social media platforms to remove content is a win for the Biden administration, because all of a sudden we've eliminated the First Amendment protections of websites and platforms. So essentially what you're seeing is, and this is something we tried to warn the lawmakers of Florida and Texas about several years ago, you're painting yourself into a corner here, because you're saying government can control speech on the internet. And then fast forward, it's the Biden administration trying to control speech on the internet, and a lot of people don't like it. So our answer is, of course, get the government out of the censorship business. And that's going to be best for everyone.
I want to ask Tommy, feel free to weigh in on this question, but I want to bring up the points you raised that conservatives are making a mistake. I mean, I guess it's kind of sort of notable that it's Texas and Florida that have challenged this, and most of the discourse. I mean, there's been critics of 230 by both the left and the right, and so bring this whole issue you're raising about kind of the conservative critique, and add to that Ash's point about, hey, the Supreme Court could, quote, dodge the issue by making a preemption argument. In some ways, that would be the most controversial thing of all, because Section 230 is like kind of red meat to a lot of people. Whereas, you can see how the First Amendment decisions, the way you all have laid it out, really dictates a certain choice. I apologize, my question's a bit rambling here, but Tommy, could you just speak to this issue of preemption, Section 230, and politically, what's the end result of the Supreme Court ruling if it were to rule for net choice?
Sure. Well, I think similarly, conservatives are being short-sighted in their criticisms of Section 230 as well. I mean, fundamentally, they both come from the same motivation, which is this notion that big tech is biased against conservatives. It's always going to be biased against conservatives, and therefore the only choice we have is more use of government, whether that's through state regulations like Florida and Texas, or through lawsuits, which is the main, I think, conservative opposition to 230, is the notion of we should be freer to have more lawsuits against big tech, like the one that was brought in Gonzalez versus Google. And I think they're both short-sighted in similar ways, which is that they don't recognize the turnover and the unpredictability of the internet, like we saw with Twitter changing to X so quickly. One of our amicus briefs at the appellate level pointed out that in the 60s and 70s, it was radical progressives who were making similar arguments of a right to access, and saying that if we don't re-envision the First Amendment as giving a right to access, conservative legacy media, which at the time was like big newspapers and the three networks, was always going to block out, radicals and anti-war people and socialists and other people who should get a platform. And therefore, we need to set new precedents and create a right to be platformed. So when you set precedents, exactly as others have said, when you set precedents based on one specific moment and give the government more power, inevitably that will be used against you, and you would see just as many, if you opened up 230, you'd see just as many lawsuits challenging conservative platforms for whether it's bias or the editorial decisions they're making, or the things they're choosing to host, or what have you.
What do others think about whether it's easier for the court to rule on the 230 issue or just on First Amendment grounds? Scott's weighed in on this, but I think it was you, Scott. But Andrew and Carl and Ash, I guess, you raised this point, Ash. But what do you think of Scott's reply to you?
I mean, he's right. If there's one thing we've learned about the Supreme Court, it's they can do whatever they want. They're not really bound by rules in quite the same way than any other court is. If they want, right now, he's absolutely correct. The 230 issue is not in front of them, but it was litigated below, so there's nothing to stop them from simply telling the parties to brief 230. And if they did, they could bring that issue back into the court. Realistically, that's only going to happen if they reach some sort of a deadlock. If they really cannot come together with a strong majority on either side, then I could imagine that happening.
I agree. The court didn't take the issue, and I think it's very loath to reach issues that the parties haven't briefed, even when it is decided upon below. I would point out that Section 230 has a very good language for those who take the more free speech position, which is one of the findings of Section 230, which you could see the court throwing this in, even if it doesn't finally decide on preemption, which again, I don't think it will. It is the policy of the United States to preserve the vibrant and competitive free market that presently exists for the internet, unfettered by federal or state regulation. That language has not been changed by Congress, though Congress has amended Section 230 since it was passed originally in 1996. So that's language you could see coming back if the court decides to take a position in favor of the platforms.
What happens with Section 230 in that legislatively? Again, I know you guys are all litigator types, but what do you think will be the political end result again in a net choice victory. We might as well take the contrary as well. But what's going to happen politically from these decisions?
So on Section 230, as was kind of alluded to, first of all, anyone on the opposition from net choice who argues Section 230 is actually making our case. Section 230 is only needed because platforms are held liable as publishers for the content on their sites. That is why Section 230 exists. So essentially, by simply raising Section 230, they are giving away the store, because that means that we are publishers, and then we are subject to First Amendment rights. So the 230 argument by the states of Florida and Texas will actually boomerang back on them and hurt them. But on the political question of Section 230, this is one of those things that I look, as I said, I'm a Republican. I go on conservative media all the time. I explain Section 230 is one of the greatest tools for non-mainstream thoughts, because it allows websites to host alternative views. We were talking earlier about the Murty cases, right? You have doctors coming out and saying, maybe masks don't work, or maybe the vaccines don't work. If a website or a platform were held strictly liable for even hosting that thought, they would never host it to begin with. So Section 230 is actually one of the tools that is most necessary for alternative thoughts. The other interesting thing that I think we're trying to educate more people on, Section 230 protects people who engage in things that are called retweets. I think they're still called retweets, reacts, whatever we call them now. And that's a big deal for anyone who retweeted that Dominion was engaged in election interference. Dominion was able to extract incredible monies due to defamation. Now imagine them going after anybody who retweeted those stories.
Right.
So Section 230 is one of the biggest gifts for free speech on the internet and alternative views. And so as lawmakers start to realize that, they start to back off real fast.
Well, Scott, do you agree? What do you think about Section 230 and its future after whatever decision is rendered?
Yeah, I mean, I agree with a lot of what Carl said. I think that, we've seen for a couple of decades all kinds of legislative efforts to amend Section 230 in various ways, and they haven't succeeded. Now, I guess it's possible, given the most recent congressional hearing with the CEOs of various tech companies there, that, I mean, maybe now there will be some further movement in amending Section 230, but I highly doubt it. And that's why the Supreme Court has so much power here over Section 230, why it was so frightened in the Gonzalez case to potentially screw up the internet, as Justice Kagan was concerned about, and many other, and I think almost every other justice expressed similar concerns at the oral argument. And so, and I think here, the court, given its concern in Gonzalez, I also think the court would be very reluctant to interpret Section 230's immunities for the first time, in this context, again, fearing what that might mean for the internet. So in short, I think it's very unlikely there will be a political solution through an amendment to Section 230, unless we see a real difference in approaches.
We've got a lot of discussion in the chat about platforms, how we define them. Are they analogous to edge services versus broadband internet access services, which is kind of back in the kind of telecommunications mindset, mind you. There is no net neutrality rules right now, although the administration is attempting to reimpose them again to kind of make them more common carrier like. So what are some of the panelists' thoughts on this question of carriage, right? What is a platform versus, I mean, again, if we had this world of we used to have the world of broadcast did not have free speech protection, and newspapers did have free speech protection. Reno versus ACLU in 1997, of course, put the internet largely in that newspaper camp. Is there any kind of chance of some other regime from a common carrier origin coming to become something in which, in the long term, platforms might be regulated? Any thoughts on this, kind of looking long term?
So I'm just going to make one comment and then go on mute. Social media platforms are not dumb pipes. They are constantly organizing, rearranging, and customizing the content for what users want and what messages they want to perform. They are not dumb pipes, as opposed to a letter carrier where you put the mail in, same thing in, same thing out. Whether you're doing a phone call, same thing in, same thing out. Totally different. And I'll let my other fellow panelists delve further, but when it comes to the common carrier argument, it's essentially our opponents just grasping at straws because their boat is going down. That's mixed metaphor, but just kind of roll with it.
I should point out that the reason they're grasping at that straw is because Justice Thomas waved it around, right? I mean, he wrote an opinion that basically said we should consider common carrier status for these platforms, and that's what Texas and Florida picked up on. I agree, though, that I think the analogy is terrible. I mean, Justice Kavanaugh, as was recently pointed out at the DC Circuit, was willing to extend First Amendment editorial rights to broadband access. If that's his position, the idea that social media platforms are common carriers is nuts. And there's also a fundamental, the point about the dumb pipes thing, the argument that's being made for the common carrier status is common carriers transmit information transparently. Social media platforms don't, therefore they're common carriers. That doesn't make any sense, right? It's like saying the New York Times has a liberal bias in its editorial page, which it does, and therefore we're going to regulate them. I mean, that's essentially the argument that's being used here. It doesn't make any sense. It's a terrible analogy. As I said, I think we have to give up on the idea that any analogy is going to be perfect, but that's a terrible analogy.
Two points on this. Center for Growth and Opportunity and Google v. Gonzalez, Gonzalez v. Google pointed this out. The content moderation is the product. If you don't moderate your content, you have garbage. You have a sea of chaos. You have to moderate it, and that's what they sell so that they create the forum that they want. It's why it has to be a form of expression. It's not only a necessary predicate to the product, it really is, in a sense, the product that it's why the word platform is problematic. It's not just a platform. A platform sounds like you're neutral. You're just whatever shows up on the platform. That's not how it works. As Carl said, you have algorithms that are written by human beings executing human judgments. Section 230 recognizes this, and it has a term of art for it, and it's called something tools, content moderation tools, or something like that. The statute itself recognizes, as Carl said, these are not dumb pipes.
Just to add one quick thing there is, I think, and I think others on this session maybe have used this terminology, and maybe Ash, you have, but these really should be conceived of as communities, at platforms, as trying to shape communities, and they are different. I mean, look at X versus X, Twitter versus Facebook versus others, and that's all just a very important way that they are not dumb pipes. They are trying to create communities for their users, and that is why they moderate content often in the way they do.
Well, our time has flown by. I have one final question, which I'll let each of you springboard to any final statements. What is the biggest policy issue outside of those that have been briefed that could impact the Supreme Court's consideration of the Texas and Florida law? And granted, we've talked about how the Supreme Court can do whatever it wants. So what do you think it might do? And let's go in the same order we started in. So Andrew, and then Carl, to end with Scott.
It's not a policy issue, but so I'll duck the question and be like a politician on TV. But I think the thing that your viewers need to keep in mind most prominently is Murthy v. Missouri, this other case that the Supreme Court is going to hear argued on March 18th, together with another case called Vullo out of New York, involving coercion by the New York state government of insurance companies not to do business with the NRA. All these cases are tied together. So you want to follow the issue knowledgeably. Don't just pay attention to the net choice cases. Watch Murthy and watch Vullo, March 18th, Supreme Court.
Awesome. Carl.
Yeah, a lot of Supreme Court watching, and as Andrew said, those are key cases. I think the other component that's kind of lurking in the background, of course, it's an election year, and massive changes to the internet will certainly disrupt the election process. And suddenly politicians will start having their campaign ads alongside horrible content that they probably don't want to have their ads next to or aligned with. So we expect the Supreme Court will decide, just like it has for the past 200 years, just like it did in 303 Creative last year, and with an eye on Murty, that websites have First Amendment protections and find in favor of NetChoice and CCIA and gets states of Florida and Texas.
Ash Bhagwat?
I agree on that last point. I think that's very likely to be the outcome. I think that the big policy question, aside from the Murthy and the job owning issues, is I think we need to think about what we need to do about the big policy question that's going to be the fight is minors. And to what extent do we want to limit minors' access to platforms, or at least shape that and sort of implement some parental controls? I mean, that sort of stuff is not inconsistent with generally First Amendment rights. And I think that's the big policy fight that's coming up.
Thank you for raising that. We've had discussions on that in the past. Tommy?
Sure. Well, I agree this is really all bound up and closely related to the job owning cases, the Murty case. I think it's very important, and I'm hopeful that the Supreme Court will be careful with its language, especially in the job owning cases. Sometimes it may well be the case that a private platform has been pressured and that you can sort of treat the decisions they made as having been puppeteered by the government. But the language we need to use there is very important. They're not becoming state actors if that happens. If that happens, the platform is just as much a victim as the individual who maybe was deplatformed or whatever based on that pressure. And I think that one of the things that the Florida and Texas might be hoping for is to blur that line and to say, oh, well, because of this job owning, this behind the scenes pressure from the government, Facebook and Twitter are really state actors. And that's just getting it backwards. You don't lose more rights and become more restricted and be treated as a state actor because you've been the victim of coercion from the government.
Great final points there. You get the last word, Scott. Oh, you're on mute though.
Thank you. I would say that the court will need to harmonize its decisions in the NetChoice cases and the Murthy case. They'll probably all come out at the very end of the court's term, and they should at least make an effort to harmonize them. I think they will invalidate the must carry provisions in NetChoice, but I also think they will try to write it narrowly so that, for example, certain types of laws could be constitutional under the First Amendment in the future. And I think they will be very mindful of the cases that Ash just referred to. They will be very mindful of the statutes that are already coming up in cases that involve protecting minors, and they will be very careful about their language so they won't sort of be prejudging those cases unless for some reason they really want to.
Well, that will have to be the last word. It's been a great discussion. I've learned a lot. I really appreciate everyone's time. Thank you, Andrew Nichols, Carlos Vado, Tommy Berry, Scott Wilkins, and Ash Bhagwat. I'm Drew Clark, and I'll see you next Wednesday at 12 noon Eastern Time. Take care, everybody.